I think that she can speak not only to, the Giuliani element of coming down to Georgia, being at these hearings that happened in December in which Giuliani and others were making false claims to Georgia state officials in an effort to persuade them to call a special session of the General Assembly and then, appoint Trump electors. But she also can speak directly to things that Trump was doing in some of these overt acts that are alleged in the indictment.
I'm Benjamin Wittes, and this is the Lawfare Podcast, October 25th, 2023. Another morning, another surprise plea deal in Fulton County Superior Court. Jenna Ellis, this time in front of Judge Scott McAfee, pleading out of the Fulton County election interference case. There was a tearful colloquy. There was a letter of apology to the people of Georgia. There is a cooperation agreement of some kind. And there is yet another sentence of probation. Joining me in the virtual jungle studio to talk about it all is Lawfare's Fulton County correspondent Anna Bauer. We talked about how big a deal Jenna Ellis could be for Fani Willis. We talked about how the DA's record is stacking up. We talked about who might be next. And we talked about who's going to hold out and force this whole thing to trial. It's the Lawfare Podcast, October 25th. Please, please me, Jenna Ellis. I want to start with a disclosure, which is that I know only about today's plea, what has come across my phone in the form of news alerts, because I've been at a conference all day, and so I know Jenna Ellis pled out, but I am really in a position to impart no useful information to the general public here. So, Anna, what happened?
Right. Well, as you know, Ben, Jenna Ellis pleaded out, although it is interesting to me that it sounds like you are on the pled side of the pleaded versus pled debate.
I'm on the use whichever feels right at any given moment. I consider them synonymous. I feel about this issue the way I feel about the Oxford comma, which is in the wars over pleaded versus pled, I am a conscientious objector.
Yeah, I think I'm a conscientious objector as well, but I'm going to use pleaded to say Jenna Ellis pleaded today in Fulton County Superior Court. It was another kind of a surprise. We expected it. I'd heard rumblings last week that there was potentially something in the works there, but it came together this morning on the tail end of Kenneth Chesbrough and Sidney Powell also pleading on the eve of their expected trials. And what happened this morning, Ben, is kind of similar to what happened with Sidney Powell and Kenneth Chesbrough. Specifically, it's very similar to the Chesbrough plea. Jenna Ellis pleaded to one count. It was a felony count of aiding and abetting false statements and writings. And that relates, of course, to, the false statements and writings that folks are accused of making before the Georgia legislature during those Senate hearings that went on in Georgia in December of 2020. In terms of the probation conditions or the conditions of the negotiated plea, again, very similar to Chesbrough and Powell, she has to write an apology letter to the citizens of Georgia, which she read during this plea allocution in which Jenna Ellis became very emotional and teary-eyed and said that she feels much remorse, and had she known what she knows now, she would not have represented Trump in his post-election efforts. She also said that, she had relied on attorneys who had much more experience than she did, and kind of made, these statements that seemed to implicate some of the co-conspirators or alleged co-conspirators that she was previously alleged to have been in a RICO conspiracy with. So that includes folks like Rudy Giuliani and Ray Smith, who was their local counsel down in Georgia. So in terms of other conditions, she has to pay $5,000 of restitution. The recommended sentence, which Judge McAfee accepted, was 5 years of probation. And then interestingly, Ben, in these other plea hearings, we've heard the prosecution say you must testify truthfully at all future proceedings. But a little bit different language was used here where they said you must fully cooperate with the prosecution in future proceedings against your, co-defendants. And I thought that was really interesting because it was a slight change in language. It went from, testify truthfully to fully cooperate. And I'm not entirely sure if that has any significance yet because I haven't seen the actual written final disposition of Jenna Ellis's case. So I don't know if potentially, that was just a little bit of a quirk in the court officer's language, but it is quite interesting that language was different. And so I think that gives you a good summary of what happened. But it is, a little bit of a surprise that we saw Ellis coming in today. But at the same time, I think you and I both figured last week that we would see some more pleas coming. So that's it.
Yeah, and we've had our eye on her specifically for a plea, in part because she's had so much trouble raising money and Trump is not paying her legal bills. And there is no quicker way to force somebody into the arms of prosecutors than to not pay your co-conspirators' legal bills. It's like not paying mercenaries. So, all right, let's talk about a few elements of this. The first is what she pled to. It is a felony, but so like Ken Chesborough, she is pleaded to a felony, but it's no jail time. And is it a first offender matter in which it'll get wiped from her record when she finishes her probation, or is this a more durable felony?
No, that's right. So she does a part of the negotiated plea is that she'll get First Offender Act status. And that effectively means that, there's a withhold of adjudication if she completes the conditions of her probation and sentence and kind of stays out of trouble, then effectively her conviction will be erased and she will be able to say in a few years' time that she's never been convicted of any, criminal charges and that kind of thing. So it is something that, is very desirable for someone, especially who has a bar admission to watch out for. Jenna Ellis, of course, has already been censured by the Colorado State Bar. She, entered into this stipulated agreement in which she admitted that she made misrepresentations about the 2020 election. And also, as we've seen with Scott Hall, Sidney Powell, and Kenneth Chesborough, the prosecution agreed to make a statement that this is not a crime of moral turpitude, and that can have some kind of effect on bar disciplinary proceedings in some states and some jurisdictions. So I think that, for her, this is a very good deal, as it has been for the other people who have pleaded out. We have seen a little bit of progression in the sense that it went from Scott Hall pleading to several misdemeanors to then now we've gotten into this territory where Kenneth Chesborough was the first felony plea. And then also we see Jenna Ellis pleading out to a felony. I'm very curious to see going forward if we're now getting into a different kind of wave maybe of deals in which the prosecution makes more significant demands about whether there will be time served besides just a probationary sentence. So we'll see.
Yeah. So, I mean, let's come to not who's next, because we obviously don't know who's next, but the baskets of defendants remaining who pleas might reasonably be anticipated from. We'll come to that in a moment. So let's talk about her statement of regret. You mentioned that there was a kind of tearful apology. I've seen a little bit of social media mockery of her grief and remorse. How do you take it? Do you see this as some kind of an act, or as a sincere expression of regret at getting caught, or as something that we should take more at face value?
I mean, it's really hard to say. It is very interesting that she chose to make this statement publicly. Sometimes I think a defendant would choose to make that kind of statement if they're concerned that maybe the judge wouldn't accept the recommended sentence, by the prosecution. There are various reasons, but in this case, I kind of just wonder if it has more to do with her concerns around her future legal career and potential bar ramifications. Although she did have that previous agreement to be censured by the Colorado State Bar, I just kind of have to wonder if maybe there were some concerns around the effect that this might have on her legal career. She's 38 years old. She's not, like Kenneth Chesbrough, who has had a long legal career and maybe isn't as concerned about being disbarred because he's at the retirement age, right? He's in his 60s. Same with Sidney Powell. But I'm not really sure what to make of it, because Jenna Ellis, on one hand, has on social media been quite resistant to, she's made a lot of statements critical of Fani Willis and the prosecution. And, as of like 2 months ago, she was smiling in her mugshot. And putting that mugshot as her profile picture on social media. So she's been a little bit defiant. And then this is a totally different kind of picture of Jenna Ellis that we got in court today. And so I'm not entirely sure what it all means, but it was quite interesting. But I'm interested to hear your take on that, Ben.
Well, I obviously didn't hear it, and so I'm working off of yours and others' descriptions of it. I will listen to it on the Lawfare No Bull feed, where, by the way, you can listen to all of these hearings unfiltered and uncut. You can subscribe to Lawfare No Bull and listen to Jenna Ellis's plea allocution yourself, as well as, Mr. Scott Hall's and Sidney Powell's excellent Blanche Dubois, like, oh gosh, about her age and her youthful countenance, and Ken Chesbrough. So, you can do exactly what I'm going to do and listen to this. That's Lawfare No Bull, wherever you get your podcasts. Look, I mean, my sense of Jenna Ellis is that she was loyal to Trump up until the point that there was an issue about paying her legal bills. And so I'm a little bit cynical about an apparently tearful statement of remorse at the dirty work she did for him. That said, I don't really know, obviously. And I do think that these, often what triggers a break and a realization that, oh my God, I'm on the wrong side of a moral and legal question, is actually less important than psychologically than the fact of the break. And so I don't know. I guess we'll have to watch over the course of these proceedings how she comports herself and how credibly and fulsomely she testifies. Which brings us to the cooperation component of the agreement. I saw that Andrew Weissman tweeted that this was a qualitatively different arrangement than had been reached with Powell and Chesbrough, because it did involve a full requirement of cooperation and interviews, not just a requirement to testify truthfully when called or if called. I take it there was as with the others, a Fifth Amendment waiver as to, any questions she might be asked. I mean, she's exposing herself to potential federal liability, right?
Right.
And so you said you weren't sure how substantial that difference was. My sense is that the difference lies in her being obligated to help them behind the scenes, not just to submit a proffer and then testify in a fashion consistent with that proffer. Is that your understanding as well?
I think that's right. I will say that there was also some language, as this was similar to Chesbrough and Powell as well, but there's language in there about also providing additional documents at the request of the prosecution. But with that said, it's subject to any lawful privileges that were asserted in good faith prior to the entry of the plea. So I think that, it's unclear to me what potential documents they might get that they didn't already have. But I do think that it's right that the qualitative difference is the kind of continued cooperation by sitting for additional interviews, sitting for answering additional questions that potentially Chesbrough and Scott Hall and Sidney Powell are maybe not bound by, although I think you could read the way that their deals are written to maybe also include, just additional cooperation in general as well, because it kind of talks about, future proceedings. It's not just at trial.
Right. So, and there's a very important distinction here between the Georgia state system and the federal system, right? So in the federal system, you would typically defer sentencing in a situation like this until after the cooperation was complete. And so you'd basically say, okay, you agree to cooperate, and we, the government, agree to submit a 5K1 letter describing your cooperation before sentencing, and we both agree to defer sentencing so that you have an opportunity fully to cooperate and make yourself really, really worth it, and we have the opportunity to benefit from your assistance before we have to describe that assistance for purposes of a substantial assistance letter. And that's a really, really powerful tool that the government has to incentivize maximal compliance. And it's also, frankly, to the benefit of the defendant, because you can make yourself super useful in a fashion that really reduces your, makes the government more and more enthusiastic about you and less interested in putting you away. And so there's here you don't see any of that. The sentence is delivered the same day. And so you kind of have it's not entirely clear to me what functionally the difference is between an obligation to testify and a waiver of the Fifth Amendment rights, which means they can call you and you've submitted a proffer, so they basically know what you're going to testify to. And then that on the one hand versus an obligation to assist or to cooperate, but without the lever of deferred sentencing. By the way, she's already gotten the benefit, which is that all these charges are dropped and she knows what sentence she's getting for the charge that she pleads to. So it's not clear to me that the difference is as great as Andrew thinks it is for purposes of that would be in the federal system.
Right. And I also will say, I just think that people are making a lot of what the court officer kind of explained in court versus I would want to actually look at the written conditions, because I don't think those are available on the docket yet. And for example, the last time when Scott Hall was making his plea and during his plea hearing, the court officer kind of changed the language of one of those conditions a little bit when they were being asked, or were kind of when Scott Hall was being asked to respond in court, whether he understood the conditions. And it was a slight change, but it did make it quite different from what I understood that condition to be when I was listening to it, and then when I actually saw the final disposition form. So I think that people should be a little bit cautious about kind of making conclusions about what all of this means in terms of the language change before we actually see on that final disposition form what the actual written language of the condition
Yeah, that's
is.
a wise point. Everybody's working here, I think, off of an oral statement in court, not off of the written documents, and that's a good caution that we should wait to explore the difference to a situation in which we can compare the written language to the written language. All right, so let's talk about what Jenna Ellis has to offer Fani Willis. Jenna Ellis was, as best as I can tell, not a particularly big fish in the Trump post-election legal effort, but she was a kind of spokeswoman for the legal team. I'm not sure how much actual legal work that she was doing, but she was speaking for the team a lot. And she did seem to be somewhat attached at the hip to Rudy Giuliani. So what do we expect that she knows about if we assume a maximalist, like she knows everything she was involved in? What do we know that she was involved in?
Right. Okay. So when you think back to the Fulton County indictment, in building this RICO case, you've got to prove 2 predicate crimes. And then you also have to prove that each of the conspirators were a part of an enterprise that had a common objective to overturn the results of the election. And they did that through both these predicate crimes and a series of overt acts to further the objective of the conspiracy, which was to unlawfully, overturn the results of the 2020 election. And so we have this mix of both predicate crimes that are alleged and then overt acts furthering the conspiracy that are alleged in the indictment. And Fani Willis chose to kind of center it around various different kind of subplots or sub-conspiracies that furthered that overarching objective. So we have the breach of voting systems in Coffee County, and that's kind of Scott Hall and Sidney Powell can speak to that. Then we have the fake electors plot, and Kenneth Chesbrough can speak to that. And I think what Jenna Ellis offers is one of these other kind of areas of focus within the indictment, which is this effort to pressure state legislatures to overturn the election by appointing Trump electors in states that Biden had actually won and that the electors were going to be electing Joe Biden. And instead, they did things like, for example, in Georgia, came down to Georgia, had these hearings in which false statements were allegedly made about the election. And the effort was to try to persuade state officials to call a special session that would then allow them to appoint Trump electors instead of Biden electors. So Jenna Ellis has a lot of knowledge about those efforts, about this pressure campaign on these state officials. In the indictment, it alleges, that she was privy to various different meetings with Pennsylvania officials and Arizona officials. And then, of course, she was involved in the planning of these hearings that were in Georgia. So, she has kind of all of this different involvement. And in some of those meetings in the indictment, Trump is alleged to have been there and himself made false claims to some of these state officials. For example, with, I believe it's the Arizona delegation that he was on a call with. So I think that she can speak not only to, the Giuliani element of coming down to Georgia, being at these hearings that happened in December, in which Giuliani and others were making false claims to Georgia state officials in an effort to persuade them to call a special session of the General Assembly and then, appoint Trump electors. But she also can speak directly to things that Trump was doing in some of these overt acts that are alleged in the indictment. I also will add as well, I recall that last year when when Fulton County prosecutors wanted Jenna Ellis to come in and testify before the special purpose grand jury, they were also focused on some memos that she wrote. She wrote a memo to Trump, and then she wrote a memo to Jay Sekulow, who is one of the people who was also advising Trump at the time, in which she was, setting out procedures to have Mike Pence potentially block the joint session of Congress on January 6th and have Trump elected instead. So she can really, I think, speak to a lot in a way that is also, I think it's important to mention that Sidney Powell and Ken Chesebro both have respective issues in terms of their value. In Sidney Powell's case, it's because she is in many ways just not a credible witness.
She's a little bit cray-cray.
Yeah, exactly. I was trying to put it more delicately than that, but yes. And then in Ken Chesebro's case, I think that it's that he didn't quite have the access directly to Trump, or even to some of these other people like Giuliani. Yes,
right. He's writing memos, emailing the inner circle, but he's not actually in the meetings. He's not there. He's a nerdy guy from Wisconsin.
Yeah, he's a nerdy guy from Wisconsin who is more kind of in the clouds, like thinking about legal, like kind of, unlawful legal theories, as opposed to Jenna Ellis is in the room. She's hanging around with Giuliani all the time. She is someone who just has a lot of that knowledge, and then also potentially would be a more credible witness than someone like Sidney Powell.
Yeah, I think there's another factor that makes what you're saying important, which is that, if you think about these interactions with state legislators, right, and you think about the way it presents in court, where the witnesses, say Rusty Bowers or those guys from Michigan, the witnesses say, okay, we had a meeting in which they pressured us. And then on the other side of that are the defendants, who are the ones being accused, who kind of say, no, we didn't. We were just, trying to take care that the law be faithfully executed. But now you have people from both sides of those meetings, those interactions, saying effectively the same thing. So, presumably her testimony will be roughly consistent with what the people on the other side are going to be saying. And that's, I think, becomes powerful, that you have people from the Trump team saying, yeah, he really did, or we really did on his behalf, or the enterprise really did the set of things that the people pressured are saying that it did. I do think that's a significant change.
No, and I think that's right. And Fani Willis, I'm curious to ask you about, Ben, because when this indictment came out, everyone was kind of saying, she went too big. It's too sprawling. It's too massive of a case. We were a little bit more reserved and kind of withholding judgment on whether or not, that would turn out to be true. But I think in many ways, the events of the past few days have vindicated Fani Willis's charging strategy. So, I mean, do you agree with that or no?
On a tentative basis, I absolutely agree with it. I do want to emphasize we were much more cautious than a lot of people. A lot of people said this is over, she's being too sweeping, she's trying to shoot the moon. And I believe what we said was that whether this strategy is touched by prosecutorial genius or whether it is a little bit shooting the moon, you will have to see in the way cases play out. So far we have 4 cases that have played out, and they've all played out the same way, which is that people have pled out to fairly generous terms. And 2 people, Ms. Powell and Mr. Chesbrough, tried to stare her down by invoking their speedy trial rights and forcing her to go to trial for a second time, because she's going to have to do the same trial, was going to have to do it again for the other 17 defendants, force her to do that in a crazy short amount of time. And she very calmly said, okay, we'll go to trial in, beginning of this week, it was supposed to be, or November 7th, by the time you have a jury selected. And both of them blinked, which whether that was because they were bluffing to begin with, or whether that was because they were trying to run out the speedy trial clock, we'll never know, because they don't have to show their poker hands. But they folded, and they pled on terms that are roughly the same as the one that Scott Hall pled out to, and now the ones that, and as you rightly point out, Jenna Ellis is elevating. She and Powell both, or Chesbrough both get the felony plea. So she does seem to be inching up. I would say if you were trying, it is still too soon to evaluate this, because she does have 15 more defendants to go. But so far she's 4 for 4. And 2 of them anyway, or at least 2, maybe 3, are relatively significant defendants. I mean, Jenna Ellis was Rudy Giuliani's right-hand woman. Sidney Powell was the Kraken lady. And Chesbrough is one of the conceptual masterminds of the thing. So these are not small gets, even if they're no prison time, single misdemeanors or single felonies or multiple misdemeanors. I would say if you had to grade Fani Willis right now, you would give her an A. Now, but that's the thing about indicting 19 people, is that, you can get 4 convictions and still lose. So I would say it's still premature to evaluate. But if I had asked you, where would we be October 24th, the day this indictment came down, what would you have said?
I don't think that I thought we would be here, but I also think the speedy trial demands change things a lot.
But they didn't change anything for Jenna Ellis.
Right. No, exactly. And well, they maybe did in terms of just speeding things up a little bit for Jenna Ellis. Maybe she would have waited until some of the dispositive, if there hadn't been these speedy trial demands. I don't know exactly where along the line we'd be, but these speedy trial demands, I think it's significant, and people need to kind of understand this, that, a lot of those motions that McAfee decided were pure questions of law about the RICO Act and its application. And of course, we don't know how they would have done on appeal, because McAfee kind of made this blanket statement that he wasn't going to allow any interlocutory appeals. But by rejecting a lot of those things about, the continuity question or the pecuniary gain question, or a lot of these things that we talked about with Chesbrough's team when they came on the podcast, I do think that, that put a lot of those defendants who were in the larger group with Trump, who were scheduled to have this later trial, that I think put them all in a position of really thinking like, oh man, maybe some of these things that I thought might work out, I'm already seeing that they're maybe not going to. They also then have this kind of psychological effect of, I've seen Scott Hall plead out, I've seen Chesbrough plead out, I've seen Powell plead out, and everyone wants to get in while the getting is good. So I do think that, the speedy trial demand had a big effect. And it's going to be very interesting to see, will we have a lull here where some of these other defendants just wait it out? or will some other one step forward now that Jenna Ellis has pleaded as well?
Right. So let's talk about them less in terms of individuals, because I think it's hard to make individual calculations speculatively about what people are likely to do. But there are certain groups of defendants, right? Presumably, Fani Willis is not looking for a plea deal with Trump or Giuliani or Mark Meadows, who aren't presumably looking from one for her. Do you agree with that? That there's a group that are sort of like the targets of the indictment, most importantly Trump, and those people are gonna end up going to trial.
Yeah, it seems like the people that team cares the most about prosecuting and maybe would be willing to drop everyone except these four would be Trump, Giuliani, Eastman, and Meadows to an extent. I still kind of wonder, I think that they probably would be happy to give Meadows a plea deal depending on how good it is for them, how mutually beneficial it is for them. But to be determined. But yeah, I think that, and even if they got down to just Giuliani and Trump, I think that they would be fine with that.
All right. So that takes us from 15. If we lop off those four and say those are the really big fish, don't look for a short-term plea deal with them, though anything's possible. Now you're down to 11. How would you group those? I mean, you got your remaining Coffee County defendants who are, I think all of those are plausible plea material, right?
Yeah, I think so. But I also will say, I think at least in the sense of Kathy Latham and Misty Hampton, you've already got two people from the Coffee County kind of area that have already pleaded out. And the case against Latham and Hampton seems very strong.
Right.
So, while they may be people who could get a plea deal, I'm would be a little bit surprised because if they weren't willing to go ahead and plea out while the getting was good and while they knew that the state had a very strong case against them, at least with respect to the Coffee County stuff, then I might be a little bit surprised to see them then, later on plea, but we'll see.
Yeah, I would take that the other direction, which is Fani Willis needs a plea from them less because she's already got Scott Hall and Sidney Powell. And so the price of it just went up. But I still think if you're them paying for a 4 to 6 month trial, sitting there next to Donald Trump and getting a RICO conviction, I don't see how you afford either financially or in terms of risk to go to trial with that. And so I would still look for that group to have a serious come to Jesus moment with their lawyers, and at some point between now and when the thing goes to trial, I would look for them to plead. Who else are we talking about here? Like, what are the other? You've got the political operative types. What other groups are there?
Yeah, so you've got the kind of the local. So you've got like these like local campaign or lawyer types. So it's like people who were working on behalf of the Trump campaign, working on these post-election efforts in Georgia. So that's people like Ray Smith, who's an attorney. You've got Bob Cheeley, those folks who maybe a lot of people don't know about, but were a part of these efforts, in terms of making the statements in front of the legislature. Right. Bob Cheeley is also alleged to have been involved in the harassment campaign against Ruby Freeman. And on that note, you've got the group of defendants, which this is an area I'm keeping my eye on because it is one of the areas of the RICO conspiracy of these little subplots that Fani Willis has not secured a plea from anyone, and that is the harassment campaign and intimidation campaign against Georgia election workers. So that's people like Trevion Cuddy, Stephen Lee, Harrison Floyd, those folks, which, it may be that for some of them, there are reasons why they wouldn't plea out because, for example, in Harrison Floyd's case, he seems like he's very much a true believer. He's been very outspoken about thinking that he's being, politically prosecuted, and he's kind of had a whole brand that has gone with, being prosecuted by Fani Willis's office. Yeah, but still, I'm watching that group of defendants to see, because it seems like Fani Willis is going to want to get someone in each of these little subplots that would plead out. In terms of other groups of folks, we've got the people like Mike Roman and Jeffrey Clark, who were, very connected to the Trump administration or the campaign. Mike Roman is more of a campaign operative. Jeffrey Clark, of course, was the DOJ official who at one point Trump toyed with appointing to be acting attorney.
He did appoint him for half a day or something. Yeah, I mean, I would just say I think Clark is more in the Eastman category of somebody who, and if you think about like the question of what Georgia and Fulton County's equities are in prosecuting an individual, some of these people, like Sidney Powell, have a very attenuated connection to anything that, bad that happened in Fulton County. And, but Jeffrey Clark, the major thing he wanted to do was send a letter to Georgia, to the state of Georgia, saying falsely that there were grave concerns, that the Justice Department had grave concerns about the integrity of Georgia's election. And so if you're a Georgia law enforcement official like Fani Willis, I do think there's an interest in Jeffrey Clark that is, a little bit different from sort of just the generic. I mean, this guy actually tried to use the Justice Department to use the federal government to, on the basis of false pretenses, interfere with Georgia elections. He's a little bit closer, I think, to the kind of molten core of the why is Fulton County interested in this question than, for example, Jenna Ellis is, or than Sidney Powell is, or even Ken Chesborough.
Yeah, and I also will say I think both Clark and Eastman, if we're putting them in the same bucket, I would be surprised if either of them pleaded out, because they both seem to be true believers. Like Jeffrey Clark's attorney was in federal court during the removal proceedings, basically kind of making an argument that the 2020 election was stolen. Eastman has been having these bar proceedings in California that has been centered around him basically proving that, the 2020 election was stolen. So I really would be surprised to see the two of them plead out because of maybe some of their ideological or personal beliefs that maybe would go against all the other incentives that would usually compel someone to plead.
So if you had to divide the 15, it's 15, right, remaining defendants into the likely pleas, unlikely pleas, it's kind of like 10-5, right? So you've got like 5 people whose whole existences at this point is wrapped up in the Trump martyrdom, and you've got 10 or 11 who may be more in the what's the best deal I can cut for myself department.
Yeah, I would also add to the kind of maybe group of people who are not quite, as connected as Eastman and Clark were to the Trump White House, but also have these more of political or ideological beliefs. David Schaefer, who of course was the former chairman, one of the fake electors, He is someone who I think I would be very surprised to see him plea out because of, his political views. And then this one is a little bit more, I'm not sure. I'm on the fence about what he might do. But Sean Still, who is a sitting state senator in Georgia, and also, again, one of the fake electors. And, they both, along with Kathy Latham, are going through this removal proceeding. They've appealed to the 11th Circuit. I don't think that it has any chance of going anywhere. But at the same time, it seems like they are kind of waiting out the removal stuff before maybe they make any deals or make any other moves. But especially Schaefer, he is someone who I, again, would just be a little bit surprised to see make a deal.
We are going to leave it there, having predicted 9 to 11 more pleas, although the time is unclear, the time frame for those, and 5 to 6 people going to trial. Anna Bauer, thank you for joining us today.
Thanks for having me.
The Lawfare podcast is produced in cooperation with the Brookings Institution, our audio engineer. This episode was me. Any errors you hear, any bad sound, all my fault. You are the Lawfare podcast's big support mechanism, so I want you to go right now and become a material supporter of Lawfare. You can do that at lawfaremedia.org/support. The Lawfare podcast is edited by Jen Patja Howell. Our music is performed by Sophia Yan. And as always, thanks for listening.